Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. Today is our 36th lecture. Before that, our regular practice is to recite the preamble. So I request each one of you to recite preamble along with me. Then we will start. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Yes. Now, the topic is explain professional ethics in mediation and conciliation. Dear friends, this is very, very important. Explain professional ethics in mediation and conciliation. This is one of the repeated topics asked under paper 3. Paper 3 deals with advocacy and professional ethics. One of the questions is explain professional ethics in mediation and conciliation. First and foremost is how I want to address this topic. I want to quote some of the important aspects on mediation. Then I will take you to the relevant provisions provided under the Mediation Act 2023. And where do we find the professional ethics provided under those provisions? That is very, very important. So now, in India, generally, one of the Honorable Chief Justice of India, Honorable Justice N.V. Ramana, His Lordship, when he opened the Mediation and Conciliation Center, he had said in his opening speech that this mediation is already in Indian ethos. It is our tradition to do the mediation. So Lordships gave two examples. One is Ramayana, another one is Mahabharata. In Ramayana, there was a fight was about to start between Lord Ram and Ravana. But before the war begins, mediation began. Who was the mediator at that point of time? Hanuman was the mediator. And he was sent to Lanka. But it could not get succeeded. Therefore, ended in war. Coming to the Mahabharata, where fight between brothers with respect to the property is concerned, land is concerned. There the mediator was Lord Krishna. And he approached on behalf of Pandavas. But ultimately, Duryodhana did not heed or did not accept the offer made by the Lord Krishna, therefore ended in Kurukshetra. So therefore, when lords tried their best, they could not do it, and it ultimately ended up in the war. What is the message? Mediation is the voluntary process. There cannot be any compulsion on any of the parties. So therefore, Lord Hanuman as well as Lord Krishna did not impose conditions on Ravan or Duryodhana that you should enter into the settlement agreement, otherwise we will take action against you. Nothing. It was a voluntary process. They were put on alert. Do this, therefore you can save your precious time, you can save your life. There is an amicable settlement between the parties, and therefore your reputation is not at stake. Therefore, this will give you a good cordial relationship between the parties. But if you don't listen, if you don't obey the mediation process, then you end up in the war. War in the sense you waste your time, you waste your energy, you waste your money. So, therefore, the mediation is introduced as an alternative dispute resolution. Now, I would like to give two examples of great leaders, how they have mediated in their profession. One is Abraham Lincoln, former president of United States of America. Though he was in dire need of money because he was born in a very poor, humble background, but when he get cases, he used to talk to the other side and try to settle the matter at the earliest. But his peers, other advocates, used to litigate, charge for appearance fees, and they come in luxury car. But Abraham Lincoln could not do that. But Abraham Lincoln's wife used to ask, you cannot survive in this field because you are not charging money at all. You are trying to settle the matters between the parties. What is the scope? How are we going to lead our life, our luxury life? So wife used to keep on asking questions. But Abraham Lincoln politely did not reply at all. Silence was the reply. After several years, when Abraham Lincoln became the president of USA, that silence of Abraham Lincoln at that point of time gave Abraham Lincoln's wife's reply. What was that reply? Wife understood that all those lawyers who charged money, they were still practicing as lawyers. But this person has taken a unique stand that we need to bring justice to the parties by amicably settling the matter. Therefore, his honesty transferred him from a lawyer to the first citizen of United States of America. So therefore, dear friends, money is important, but defending the interest of the client is most important. Once you earn the trust of the client, you can do many things in the profession. This is the story of Abraham Lincoln. Now coming about Mahatma Gandhi ji, in his own words, in his practice, in hundreds of cases he has settled the matter through mediation. This is the quotation of Mahatma Gandhi ji. I quote, "My joy was boundless. I had learnt the true practice of law. I had learnt to find out the better side of human nature and to enter men's hearts. I realized the true function of a lawyer was to unite parties riven asunder. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice," see dear friends, 20 years of practice, "that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases." This is where our Mahatma stands. These two lines. "I lost nothing thereby, not even money, certainly not my soul." See how beautifully he says, I lost nothing. I brought mediation in hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. This is what the language or of the experience, wisdom of Mahatma Gandhi ji. Now what we need to do is, dear friends, after taking cue from the life stories of Abraham Lincoln and our epics also, how a professional ethics is to be followed in mediation and conciliation. So let us ask ourselves this question: what is mediation? What is conciliation? Is it interchangeable words for same purpose, or is there any difference? Right? For this purpose, I would like to refer to the Mediation Act 2023, a very latest act, in which section 3H deals with what is mediation. It defines mediation. Let me read, dear friends. 3H of the Mediation Act 2023. Mediation includes a process whether referred to by the expression mediation, pre-litigation mediation. That means they are not defining, it's an inclusive definition. Mediation, pre-litigation mediation, online mediation, community mediation, conciliation. See, dear friends, conciliation is also the meaning of mediation. Conciliation or an expression of similar import. So you call it any name, but if it has the amicable settlement, that means it is also a mediation. Panchayat will also come under the mediation. Or an expression of similar import, whereby parties attempt to reach an amicable settlement of their dispute. So through this process, what is the object? Object is for amicable settlement of a dispute. By whom? Who will do this mediation? With the assistance of a third person referred to as mediator. So there is a third person who is totally unconnected with the facts of the case, merits of the case, and he is not interested either in the case or in the outcome of the case. So a neutral person, impartial person, independent person, third person appointed as a mediator. The assistance of a third person referred to as a mediator, who does not have authority to impose a settlement upon the parties to the dispute. So he has no authority to say, to compel the party to arrive at a settlement. From this, what we can understand is, it is a voluntary process. Both the parties must express their free consent for amicable settlement through the mediator. You call it any name: mediation, online mediation, community mediation, conciliation, or any import you bring it, for amicable settlement of the parties through the assistance of a mediator who has no authority to compel the parties to arrive at a settlement. So this is what the mediation is. Having understood what is mediation as per section 3H of the Mediation Act 2023, now where is professional ethics provided under this act? That is our question, that is our topic. So now for this, I will take you to certain relevant provisions, dear friends. Appointment of mediator is dealt under section 8. Section 9 deals with preference of parties. Most important professional ethical standard is prescribed under section 10. I am coming to the heart and soul of our topic today. Section 10, which deals with conflict of interest and disclosure. Subsection 1 says, the person appointed as a mediator, the person appointed as a mediator shall, it is not may, dear friends, it is shall, must, prior to the conduct of mediation, disclose in writing, he has to disclose in writing to the parties, to both the parties, regarding any circumstance or potential circumstance, personal, professional, financial, or otherwise, that may constitute any conflict of interest, or that is likely to give rise to justifiable doubts as to his independence or impartiality as a mediator. For example, let me give an example. A matrimonial dispute, husband and wife matrimonial dispute, has been referred to the Supreme Court mediation. Both the parties are there. Mediator is appointed. That party may be wife, she is also an advocate by profession. and she has an issue with the husband. Mediator is appointed, but mediator at one point of time he was senior under whose chamber that she has worked. So earlier relationship is mediator was the senior and she was the associate or the junior. So therefore they knew each other earlier. So whether now is it necessary for the mediator to disclose to the other side who is the husband? Yes, he has to disclose because professionally they were connected, they knew each other. So there is some sort of biasness might be there, but he may be impartial, mediator may be independent, but there is a doubt will be there in the mind of the husband. Therefore he has to disclose. That is one thing. So he has to disclose any circumstance, personal, professional, financial or otherwise also he must disclose. For what? To avoid any conflict of interest, and it should not give rise to any justifiable doubts, because in mediation independence, impartiality, that is most important, and that disclosure should be done without any delay. You cannot say after several sessions. So it has to be intimated. Once it has been intimated, husband says no problem, I have a trust in this mediator, he can give a consent in writing, then it can be proceeded. Otherwise he has a reservation that this mediator should not conduct mediation. That means another mediator can replace the old mediator. Now, how a mediation can be conducted? Conduct of mediation under section 15. It says the mediation process shall be conducted in the manner as may be specified. Subsection 2 of section 15. The mediator shall assist the parties in an independent manner. What is independency? You should not succumb to any pressure. You should have an independent thinking. Somebody should not say that I will give you this much money, decide in my favor. Where is the independence? They have made mediator as a financially dependent. So no independency was there. Otherwise I have political nexus, therefore you will be elevated or you will be promoted. So independence means he should have a independent thinking, independent in discharge of his duties. Neutral and impartial manner in their attempt to reach an amicable settlement of the dispute. Subsection 3. The mediator at all times. Dear friends, once mediation is over, doesn't mean that he can disclose. The mediation process, the mediator shall at all times be guided by the principle of objectivity and fairness and protect the voluntariness, confidentiality and self-determination of the parties and the standards for professional and ethical conduct as may be specified. So there may be rules providing the code of conduct for the mediators that has to be followed. Subsection 4. The mediation process may include the mediator taking such measures as may be considered appropriate, taking into account the circumstance of the case, including meeting with parties or participants jointly or separately, as frequently as deemed fit. The mediator, both in order to convene the mediation and during the mediation, for the orderly and timely conduct of the process and to maintain integrity. See, both the parties there can be a joint meeting also. Thereafter, the other party can be asked to wait outside and they can have an exclusive mediation also. Ultimately, amicable settlement should be arrived in a fair manner, impartial manner. Mediator shall not be bound by Civil Procedure Code or by the Indian Evidence Act. Now, role of a mediator. How a role of the mediator has to be? It is provided under section 16. The mediator shall attempt to facilitate voluntary resolution of the dispute by the parties and communicate the view of each party to the other to the extent agreed to by them, assist them in identifying issues. So he is only the mediator, is only the facilitator. And what he has to do? He has to make both the parties where they are differing, identifying issues, advancing better understanding, clarifying priorities, exploring areas of settlement, and generating options in an attempt to resolve the disputes expeditiously, emphasizing that it is the responsibility of the parties to take decision regarding their claims. And subsection 2 of section 16 says the parties shall be informed expressly by the mediator that he only facilitates in arriving at a decision to resolve a dispute, and that he shall not impose any settlement nor give any assurance that the mediation may result in a settlement. He cannot say that I will successfully complete the mediation. He cannot give any assurance. He is only the facilitator between both the parties to understand where are the differences and what are the possible manner for amicable settlement. Thereafter, dear friends, let me take you to section 22, confidentiality. This most important is whatever you say, because when there is an offer, acceptance in the mediation, there are certain things where the party compromise to achieve end result. So therefore, the admissions, acknowledgements made by the parties before the mediator cannot be regarded as an admission in the court of law. So mediation cannot be whatever you say, those terms and conditions, proposals, admissions, admission of their own guilt, but that is cannot be put outside the mediation. It cannot be accepted in the court of law. See, subject to the other provisions of the Act, the mediator, mediation service provider, the parties and participants in the mediation shall keep confidential in all the following matters relating to mediation proceedings, namely acknowledgements. He acknowledges, yes, I have done like this. He has given certain opinion, suggestions, promises, proposals, apologies, and admission made during the mediation, or acceptance of willingness to accept proposal made or exchanged in the mediation, document prepared solely for the conduct of mediation or in relation thereto, or any other mediation communication. Mediation communication means it is well within the four corners, well within the four corners of walls only, that's all. It will not go beyond the walls. No audio video recording, though mediation can be an online mediation, but there cannot be a recording. No audio video recording of the mediation, because that will breach the confidentiality. And no party to the mediation shall rely on or introduce any evidence relating to above acknowledgement, admissions, proposals, everything that cannot be relied upon. Now, what about mediation agreement, mediated agreement? Mediated agreement can be relied upon, because ultimately they were negotiating only to arrive at an amicable settlement, an amicable settlement through mediated agreement, and mediated agreement cannot be breached. Explanation: for the removal of doubts, it is hereby clarified, nothing contained in this section shall apply to the mediated settlement agreement where its disclosure is necessary for the purpose of registration, enforcement, and challenge. Now, dear friends, for example, during the mediation, if somebody says, some party threatens the other party that you sign it, otherwise I will kill you. You come outside the court, I will see to that what happens. So therefore, that is a threat, that is against the law. Therefore, such a circumstances, when you want to make a police complaint, you have to state what has happened within the mediation. Some corruption, some bribery has taken place, some illegal activities happened during the mediation process, that can always be brought before the appropriate forum. That is not kept, that should not be kept as a confidential. This confidentiality excludes such illegal activities. What are those? When there is a professional misconduct of a mediator or malpractice based on the conduct occurring during the mediation, there shall be no privilege or confidentiality that will attach to a threat or statement of a plan to commit an offense punishable under any law for the timing in force, information relating to domestic violence or child abuse. During the mediation, he says, yes, I have committed domestic violence or child abuse, that cannot come under confidentiality. Or statements made during a mediation showing a significant imminent threat to public health or safety. He says only within mediation, therefore, it cannot be brought under the confidentiality. So these are all excluded. Now, once mediated agreement is signed, when a person wants to challenge it, under what grounds he can challenge it? He can challenge it on the ground of fraud, on the ground of corruption, impersonation. I was not there in the mediation, somebody was impersonated me, impersonation, or where the mediation was conducted in disputes or matters not fit for mediation, which was provided under section 6. So on these lines, dear friends, they have communicated that how a confidentiality is to be maintained in the mediation. Now ultimately what we have seen is mediation is the alternative dispute resolution. Why it is alternative dispute resolution? One case is where we have dealt. Husband has filed a restitution petition in one state, Uttarakhand. Wife has filed a domestic violence in Rajasthan. And she has filed a transfer petition before the Supreme Court to seek a restitution petition filed by the husband in Uttarakhand to Rajasthan. Mediation matter has been referred to the mediation. Now both the parties have agreed for the settlement. Husband has paid some amount to the wife as a permanent alimony. Therefore, all the cases, restitution cases, is withdrew by the parties by virtue of Article 142 of the Constitution of India. The Honorable Supreme Court has exercised its power to quash the domestic violence case filed by the wife against the husband, restitution of conjugal rights filed by the husband. Now, by 142, they were granted mutual divorce. So, how much time that they have saved? Otherwise, they would be litigating for several years. So, through mediation, they have saved their time, saved their energy, saved their litigation cost, and they can spend constructively in their life by focusing on their profession. So therefore, when what you want supposed to get after 25 years, you are getting something today, accept it. That is what the effect of the mediation. So mediation is a voluntary process, and mediator role is only to assist or facilitate the mediation, and he cannot compel the party to arrive at a settlement. So how a mediator has to be? Now the question is, with this I will conclude, dear friends. How a mediator has to be? Mediator should have 3 bones that they are saying. What are those bones? One is wish bone. Wish bone. Another one is fun bone. Fun bone. Another third bone is backbone. So what are these 3 bones? Let me say, what are those 3 bones for the mediator? So once you want to be a mediator, please retain these 3 bones. A mediator's spine consists of 3 bones: a wish bone, funny bone, and a backbone. And it is this vertebra that defines the role of the mediator. You need to have a dream clouds floating in your head. You need a clear vision for what you want. You need drive and an innovative thought process, or simply an idea that is so simple it is out of this world. You need a wishbone. Now, coming to the funny bone, you need the willpower to sustain the setbacks in life. You need to know how to turn a frown upside down. You need optimism to see every situation with a positive twist. You need hope. You need cheer. You need a funny bone. We may have many challenges, but make it as your opportunity. And finally, to complete the vertebral column of dealing with disputes, you need a backbone. You need to know when your demands are reasonable. You need to know when not to allow someone to take you for a ride. You need to know when not back out. You need to stand up for the fundamental principle of your life. So these bones taken from which book? That is Anurup Omkar and Kritika Krishnamurthy, The Art of Negotiation and Mediation, Wishbone, Funny Bone and a Backbone, published by LexisNexis 2nd edition 2021, dear friends. Now the most important thing is the problem. Where does it arise? Arise between the difference of opinion between the parties. When they keep silence, there is no difficulty. When they start saying, opening their mouth, difficulty begins. Therefore, Saint Valluvar has said, how he has said is, இனிய உளவாக இன்னாத கூறல் கனி இருப்ப காய் கவர்ந்தற்று. What does it mean? He says, when you want to pluck mango, kacha mango, kacha aam or paka aam, fruit is there, unripened fruit is also there. When you want to eat, you have to pluck the ripened fruit and you will not pluck the unripened fruit, right? So likewise, when there are sweet words are there, why do you use harsh words? It is like you are leaving the fruit. You are taking the unripened fruit. That is harsh words. Don't do that. Once you start using the sweet words, there will not be any scope for mediation also, no scope for litigation also. So therefore, we need to learn. We have to educate our youth, not only to their mind, but also to their heart. This is what our Dalai Lama ji has said. So when you are educating, not to the minds of the youth, but to their hearts also. Therefore, they will not only carry the degree, but also they have the value for such degree. Thank you so much, dear friends. Thank you for your patience hearing. I am deeply obliged. Let us join us for a group photo.